If you are not legally protected in your business, you are leaving money on the table. Hey, I get it. The legal side of business can feel intimidating, but the good news is it doesn't have to be. If you want to build your business on a strong foundation, and if you want to know that your rights are protected when the unexpected happens with a client or a customer, then it's time to get legally protected. This means no more using free contracts that you downloaded off of the internet. This means partnering with a law firm that actually believes in your vision and can help you achieve it. This means legally protecting your brand so that no one can steal your good ideas. There are a lot of ways to grow and scale, but if you want to grow a strong business, it's time to get legally protected. If you're listening and resonating with this, then my signature service, the Legal Upgrade, just might be perfect for you. The Legal Upgrade is a straightforward, structured process to give your business the legal protection that it needs to thrive. Click the link in the show notes and schedule a call with me today. Hello and welcome to the Legal Upgrade Podcast. I'm your host, licensed attorney Christian Hammond. This podcast breaks down the legal side of business to reveal key legal strategies that can help you take your business to the next level. Please note that none of the following is legal, tax, investment, financial, or medical advice. Without further ado, let's get into the show. What does it take to actually get a trademark? What does that process involve, and how can you or your team prepare to take on that process of actually trademarking your brand and legally protecting it? Today, we're talking about one of the top questions that I get from business owners, which is, what does the trademark process actually involve? What is actually required to trademark a brand? How long does this thing take? How should me and my team prepare? So if you've had any of those questions, if you've been wondering what it would take for your business to actually get trademarked, this live stream is for you. And this would be a great time to grab a notebook, to grab whatever it is that you use to take notes, because this live stream is going to be very informational. It's going to be really valuable for you and your team. And it's also going to be a lot of information. So this would be a good time to break out that notebook, break out whatever your top note-taking source is, and take notes, because this is going to be super helpful, again, for you and your team. If you've been thinking about trademarking and you've been wondering, okay, what does this process actually involve? And before we jump into it, I am going to caveat by saying that this is definitely going to be a little specific to how I specifically handle trademarks for my clients. It's going to be a little specific to my proprietary process, but I think that it's still going to give you guys really good information on what this process involves and what this process actually requires. So hope you have your notebooks, hope you're ready, hope you're buckled in. Here we go. So the first thing to know about the trademark process is that it takes a really long time. And I usually tell my clients to just go ahead and expect to take 18 months right off the bat. So it's a long process, and it could be shorter if things go really well. It could be longer if there are complications. But I think that 18 months is just a really good time frame to ballpark it at, and to just kind of set that as the expectation. And so if you are in a position where you haven't launched yet, you haven't started your business yet, then I think 18 months is a good time frame to thinking about, okay, I'm thinking about launching next year. So this would be potentially a good time to go ahead and start that trademark process, because I'm planning ahead to next year, planning ahead to 2024 or even to 2025. If you already have a business, if you've already been in business for a while, that is totally good too. But again, I think that 18 months is a good time frame for a small business and for the team to be working with, so that the thought process can be, okay, we're starting this process now, and we know that this is going to be a next year kind of a thing. When you start a trademark process, because of how long it takes, it's not a this year kind of a thing. It's usually a next year kind of a thing as far as when you're actually going to have that registration in your hand. So I think that the first thing that typically shocks people, the first thing that kind of surprises people is just the sheer length of the process, how long it takes. And again, I typically ballpark it for people at about 18 months. So if we know that we're getting into a 1.5 year long-ish process, then for me, I'm kind of like, why would we start a process like that unless we're pretty sure we're going to be successful? So when I do trademarks for my clients, for me, the most important step is the first step that I do for them, which is due diligence. And due diligence just means I need to assess this trademark. I need to see if there's actually a shot at registration. Like, we need to find out if we're going to be successful, because this is going to take a long time, and we don't want to be sitting here a 1.5 years from now disappointed. So the very first step that I do for my clients is due diligence. We need to find out if this is even something that's available, if this is even something that can be trademarked. And that's important because there are many reasons why the government might reject a trademark application. The government might reject it because it's too similar to someone else's trademark. They might reject it because it's merely descriptive, because it fails to function, because it's geographically descriptive, because it's primarily just laudatory. I realize this is a lot of legal jargon, but the point is that there are actually a lot of reasons why the government might reject an application. And so for me, I'm like, well, we need to assess that up front. Why wait for the government to reject us later? Like, let's do that assessment now. So step one is to assess the trademark and see if it hits any of those reasons, because any one of those reasons could result in the trademark being denied and rejected by the government. So I like to do that assessment up front, so we know what we're dealing with, so we know what to expect, so we know our likelihood of success, and so that we're not sitting here a 1.5 years from now being like, what happened? So that's the very first step in the process. And I'm talking a lot about the process because the reality is that anyone can fill out a form for you, right? Anyone can fill out a form for you. Anybody can go to the United States Patent and Trademark Office website and fill out a form. And so in my opinion, if you're just paying somebody to fill out a form, that's not super valuable, right? Like, why would you pay someone just to fill out a form? And so the whole point of working with a lawyer, the whole point of hiring a law firm is to actually get the strategy. I'm not paying you to fill out this form for me. I'm paying you to tell me, what should I do? What's the best move for my trademark? What's the best strategy for me, for my business, for my industry, and for where we're at? And so I think that whenever you're working with a lawyer, whenever you're working with a law firm, it's really important to understand, like, what is their process? Because again, anyone can fill out a form. That's, in my opinion, that's not super valuable. What is valuable is the strategy. What is valuable is the advice on which way to go, especially if maybe things are looking kind of rocky. Making that judgment call of like, okay, here are the potential issues and here's the plan for getting around those issues. So I think that that's really important. And so, like I said, that very first step is due diligence. And something that I often hear from business owners, they'll come to me, or we're talking through the whole process, and they'll usually say, okay, Christian, I don't know about all that other stuff you just said. The whole merely descriptive, failure to function, all those other reasons the government might reject my application. I don't know about those, the legal jargon side. But they'll usually say, what I do know is that no one has my exact trademark. Typically, before they come to me, they've already Googled it. Typically, they've already done a bit of research. Often, they actually chose the name specifically because they knew it was unique. So typically, people come to me and they're like, okay, I don't know about this other stuff. I don't know about these other reasons. But what I do know is that my trademark is not yet taken. And the thing is, guys, is that that's not true. In other words, when the government is assessing a trademark application, the question is not just, has anyone already trademarked this specific phrase? The question is, has anyone trademarked anything close, anything similar, anything that is likely to be confused with your business name? And to kind of break that down, I like to give the example of Starbucks. So think of Starbucks. Well, Starbucks owns the trademark for Starbucks, right? Now imagine that you own Starbucks and you are the owner of this chain and you own the trademark. Now imagine that somebody else was able to come along and trademark the name Starbucks Coffee. Well, that wouldn't be fair. That wouldn't be fair, right? I mean, yeah, they added the word coffee on the end, but it's still basically the same as your trademark. It's still going to confuse your customers. It's still going to confuse your clients and make them think that they might be you. So when someone has a trademark registered with the government, they're protected not just for their exact name, but for anything that is likely to be confused with their name, which means that when you are trying to get a trademark, the government's not just looking at, okay, is this exact phrase already taken, but is anything close to it already taken? So to really have a good idea of whether your trademark can succeed, to really have a good idea of whether we're going to get to the end of this year and a half and be successful or not, I need to look at every possible permutation, variation of your trademark. I need to look at all the possible different spellings, all the possible words that might be pronounced similarly, whether there's plurals or whether it's singular. I need to look at, okay, has anyone trademarked this word in Spanish, French, Japanese, or any possible other language? We need to look at every single possibility because that's what the government is going to be looking for. So it's not just, and so oftentimes people are surprised. They're like, oh, well, I Googled this name, or like I knew no one had my exact name. That's not what we're looking for. You know, maybe they have that word plus another word. Maybe they have that word but spelled differently, or that word but it's a plural. All of those things are potential issues. And that is what we are assessing, or that's what I assess during the due diligence process. So you might be wondering, okay, cool, but how do you do this really in-depth, really thorough due diligence process? How do you actually accomplish that? And I accomplish that two ways, or this is how we do it at Bevel Law. I do a human search. So I actually build customized searches for my clients. And these search patterns and this search method is based on my own templates, which is based on my experience of what works, what doesn't work, what the government is looking for. So I build those custom searches for each of my clients and I run it in the federal database. And I also have an algorithm service that also searches and pulls every possible permutation and variation. So I do a human search, and then I also do an algorithm search. And this is just my opinion, but I think that that's the best way to do it because, some people think you just kind of rely on the algorithm service, but for me, I think that's too risky. I have actually found results during a human search that were not uncovered by the algorithm, and vice versa. So I like my clients to be fully covered, so I do it both ways. I do a human search by like myself, the actual attorney, and then I also do the algorithm. And I found that having both of those methods really provides the full picture of, okay, what are the chances of success for this trademark? Is this going to be successful? Is there anything we should be worried about? Are there potential competitors? I find that that is the best method, and that's the method that I use for my clients. So once that due diligence is finished, then I sit down and and the next part is the strategy meeting. And again, to me, strategy is so crucial because anyone can fill out a form. That's not what we're here for. Anyone can fill out a form. But, which type of application are we going to do? We going to do T's standard or T's plus? What's the basis is going to be? Are we going to do a 1A or a 1B? What's our goal? Are we shooting for that principal register or that supplemental register? Now, if you have no exposure to trademarks, none of that of what I said just now made sense. But the point here is that these are all strategic decisions. These are all decisions that go into figuring out what's the best way to apply for this client? What's the best way to apply for your trademark based on what we found during due diligence and based on what we know the potential issues might be? So that strategy meeting is really where we dig into the strategy and we start making those strategic decisions so that we can maximize the application for that client. And one of the most important parts of that process is deciding which trademark classes to choose. So again, if you're not familiar with trademarks, you might not be familiar with trademark classes. And so basically this is how it works. When you get a trademark, you're not trademarked for everything. You trademark a phrase, you don't get to own that phrase for just everything. You own that phrase for a specific area. So Starbucks has a trademark for coffee. Well, actually, they have a trademark for a lot of other things because Starbucks has other services and swag. But just go with me. Starbucks is trademarked in the area of coffee. Walmart is trademarked for retail store services. That's class 35. Your gym is trademarked in the area of providing fitness, providing a gym service. So it's not when you get a trademark, you don't get a trademark for everything. You're not applying for a trademark for everything because no business does everything, but you're applying for a specific class. If you make stickers, that's class 16. So is journals. If you make tote bags or purses or wallets, that's class 18. If you sell water bottles, coffee mugs, that's class 21. If you are an apparel or a fashion brand, that's class 25. If you have a retail store or an online store or you're in e-commerce, that's class 35. If you are a coach or a consultant or an educator or you own a school, that's going to usually be class 41. Class 41 is also podcasts, it's blogs, it's media, it's video series, it's most of what you would consider to be entertainment and education. That's class 41. If you are providing healthcare services, that's class 44. If you have an app, that's class 9. So there's many, many different kinds of trademark classes. And so during that strategy meeting, we're trying to figure out, or we're deciding which classes make the most sense. And part of that can be a revenue determination. Okay, which classes are top priority are probably going to be the classes that are top revenue for that particular client. And there can be other considerations as well. But that's one of the key things we're trying to zero in on. Which classes are the most important? Which ones make the most sense? And again, depending on how that due diligence looked, we might be making some strategic decisions about which classes to apply for and which ones not to, because maybe some classes might be kind of controversial, whereas other classes might be an easy win. So these are all decisions that we are making through that process. I see a question here, and the question says, do they all require history of use before applying? That's a super good question. And that's going to depend the type or the way that the application is being submitted. So there's more than one way to submit a trademark application. There's one way to submit it where the trademark is already in use for those goods or services. And there's another way to submit it where it's not yet being used. You're kind of trying to get a trademark reservation for something you might do in the future. So those are two different ways to do it. They can be combined. There's pros and cons to that. But there are two different ways to do it. Thanks for asking that question. So that's how the strategy works. We're trying to figure out what type of application to use, which basis are we going for, which register are we shooting for, which classes. All those strategic decisions are happening during that strategy meeting. And then the next thing that I do, again, this is my proprietary trademark process that I use with my clients, is I submit the application. And you may or may not know this, but there is a huge backlog at the United States Patent and Trademark Office. There was already a backlog before COVID, and in a post-COVID world, or not post-COVID, but kind of coming out of COVID, that backlog has only grown. So typically, I tell my clients that we're really not going to hear a response for a good 10, 11 months, almost a year. And so that is a huge waiting process and there's really nothing you can do to speed it up, unfortunately. But when we do hear back from the government, at least for the first time, then that's when the application either moves on to the next phase or the government says, we have a problem. That's called getting an office action. This is why that very, very first due diligence step is so crucial, because a bad office action can end it all. You get certain types of office actions, depending on the circumstances, and it's game over. So we don't want to get a year into it and already have it be game over and we didn't know that was going to happen. So due diligence is so crucial so that we know whether we're going to get an office action or not. Now, if the application does get an office action, there's basically an opportunity to appeal. You can try to overturn that office action, and the attorney that you're working with will typically handle that appeal or that effort to overturn the office action. But it's completely within the government's discretion whether they're going to say yes or whether they're going to say game over for you. So that's kind of the first thing that happens. I like to tell people that the first stage of that examination process is getting past the government. The government has to give you their stamp of approval in that very first stage. And if they don't, you'll get an office action. And if you get an office action, then the next stage is to try to get it overturned or to try to get it revoked. Now, after that very first stage, that office action stage, then it's time for publication. Or the way I like to say it, you got past the government, now it's time to get past everybody else. And the way I like to describe publication is if you've ever been to a wedding. If you've ever been to a wedding and there's that moment when the preacher or the officiant says, if anyone knows any reason these two should not be wed, please speak now and forever hold your peace. Have you ever been to a wedding where that happened? For me, that's just such a stressful moment. I'm just sitting there in the audience feeling so stressed. I'm not even sure why, but for me, that's such a stressful moment in any wedding ceremony. Well, publication is basically that. Publication is a 30-day period where the trademark is published in the official gazette of the USPTO. And during that 30 days, anybody and everybody has an opportunity to oppose your trademark. Again, this is why for me, it is so crucial to do that due diligence at the front end. And sometimes clients will ask me like, hey, Christian, can we just skip due diligence? And normally my answer is no. Or if you want to skip due diligence, you're going to have to find another law firm. Because I'm like, why in the world would we tackle this process with no indication of what's out there, of who might cause trouble, of whether we're going to get an office action, whether we're going to get an opposition? Like, these are things we want to know beforehand. These are things we want to know before we even start this whole long process. So this is why we do due diligence, to identify potential opposers, to find out who's out there that might oppose the trademark, who's out there that might try to cause trouble at the publication stage. Now, if there is an opposition at that publication stage, then that's when, again, we're kind of doing more heavy legal work, trying to negotiate an amicable settlement. Maybe we're trying to negotiate a consent agreement. Maybe it goes even further and we litigate. This would not be federal litigation. This would be at the administrative level, at the Trademark Trial and Appeal Board. Depending on the situation, could be different, could be different action required. But if there is an opposition, that typically is going to require some heavier legal work. Again, we need to negotiate a settlement. We're going to try and see if we can get a consent agreement. We might even need to litigate to fight it out, depending on the situation. So that is publication. And if the trademark makes it past the office actions, and if it makes it past the publication, and if we make it past any potential opposers, then depending on the type of application, and there are different options here, it's time to submit the evidence. It's time to submit that evidence showing the government that, hey, I'm actually using this trademark the way I said it was going to. I'm actually using this trademark the way I said I was going to, over a year ago when I originally submitted this application. I see another question here. Do trademarks apply globally, or is that a different process? Great question. Trademarks are country by country. So sometimes businesses do business, have clients or customers in multiple countries, and they will seek to trademark in multiple countries. So every country has its own trademark process. Most countries have their own trademark office, and there are different strategies for trademarking internationally depending on the business. There's just kind of different avenues for going about that. Some are more efficient than others depending on the situation. Good question. So, like I said, if you get past the government, if you get through publication, now it's time to submit the evidence. That evidence is called a statement of use, showing, okay, I'm actually using the trademark the way I said I was going to. This can happen at the beginning, it can happen at the end. It just kind of depends on the type of trademark application, but it's got to happen at some point. At some point, you have to show the government the receipts that you are actually using the trademark the way you said you were going to. And then if you actually get through all of that, finally, at the end, that's when you get the trademark registered. That's when we get to celebrate. That's when I get to send the client the registration certificate and say, congratulations, you are an owner of a federally registered trademark from the United States Patent and Trademark Office. That's the great moment. And so that is what the full trademark process looks like from end to end. That is what it looks like to spend that year and a half working with a lawyer, working with a law firm to get that trademark registered. And it's a long process, which means that you and that lawyer, you and that law firm are going to be spending a lot of time together. And if you are a Bevel Law client, then you know that there's a process for becoming a Bevel Law client. You had to fill out a form. You had to be willing to book a discovery call and have a conversation and have a 30-minute conversation. And that's intentional because this is a year and a half long process. We're going to be spending a lot of time together. So we need to make sure that it's the right fit for you, that's the right fit for the firm. And I think that is so crucial. I think that too many business owners don't take fit into consideration. Too many business owners don't consider that most legal projects are long term. And so it's a good thing to find a lawyer that you actually enjoy working with. And I say this all the time on this channel that I am not for everybody. Bevel Law is not everyone's cup of tea, and that is totally okay. What's important to me is that, and I think that small business owners should keep in mind, is finding that right fit. Finding that law firm, finding that lawyer that you really connect with and that is the right fit for your business. I think that's so crucial and just so underappreciated, so underplayed, just something that people don't think about because legal projects are long. They're very long. So speaking of long projects, at this point in the process, a lot of times my business owners are feeling overwhelmed. They're like, oh my gosh, I thought this was going to be quick. I thought this was going to be easy. I was not anticipating that me trying to trademark my brand would involve all of this. And if you're feeling overwhelmed, the good news is that's why you hire a professional. That's why you hire a professional. When That's why you delegate these things, so that you don't have to be concerned with deadlines and process and project managing all this stuff. This is exactly why you hire a professional. And so for my clients, everything that I just described to you, I handle it all. I do it all for them. Yes, they have to provide me some information. I need some sales data from them. I need some feedback from them. But as far as the actual work, managing the deadlines, dealing with the government, negotiating settlements, dealing with opposers, I do all of that for them. And that's why you hire a professional. That's why you hire an expert, so that you don't have to be worried about that kind of stuff. So if you're feeling overwhelmed, don't be. That's why you hire a professional. That's why you find a good law firm to work with, so that you don't have to worry about it. So that's what I have for you guys today. Thank you guys for your questions. And if you have any other questions, you can feel free to send me a DM. But if what I described to you resonated with you, if you are looking to trademark your brand and you have been looking for a professional law firm to just handle it for you, because you don't have time for that. You're the business owner, you're the CEO, you're the founder. You do not have time to handle the details. You've been looking for a done-for-you professional service. Then feel free to reach out. You can click the link in my bio. You can schedule a call, and that'll allow you to set up a call with me so we can talk through it, and I can learn more about your business and your goals and what you're looking for. But if you've been looking for a professional, done-for-you trademark solution, feel free to reach out, and we'll see if we can get you set up for that. So thank you guys so much for joining. Thank you guys so much for being here today, and I will see you guys next time. Bye. Hey, thanks for listening to the show. The Legal Upgrade Podcast is a Bevel Law production. For more information about the Legal Upgrade, you can follow on Instagram at Bevel Law, or find even more information on the website bevellaw.com. If you enjoyed the episode, please remember to subscribe, leave a review, and share it with a friend. See you next time on the Legal Upgrade Podcast.